أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وآله الطيبين الطاهرين اللهم صل على محمد وآل محمد. Respected brothers and sisters, Assalamu alaikum wa rahmatullahi wa barakatuh. I welcome you to our Islamic Law 04 class as we discuss the fiqh of Ahlul Bayt, peace be upon them. Last year we started the chapter of transactions. Transactions is called Al-Uqud in Arabic. Uqud is the plural for the word Aqd. Aqd means a contract. And we had a brief discussion on the types of contracts that there are. And then we started to examine al-bay', the transaction of buying and selling. In Islamic law, it's very important that we observe the laws of Sharia when it comes to our business. As one hadith states, 9/10 of worshipping Allah subhanahu wa ta'ala is what? Is doing business, earning a halal income. Many people do business, but they do not observe the laws that Allah subhanahu wa ta'ala has prescribed for us. And we end up violating the law of Allah subhanahu wa ta'ala. So it's very important for us as believers to be familiar with the book of transactions. I know many pious individuals, when it comes to the book of salah, the book of fasting, they know the details. They've done due diligence to know the details. But when it comes to the book of transactions, al-uqud wal-mu'amalat, they're not aware of that. And they end up making violations. And this is troublesome, this is problematic. So in this course, we examine the laws of transactions. Previously, when we ended last year, we discussed a number of important aspects of transactions. And we arrived on page 40 of our book. If you don't have the book, inshallah we'll pass out the books later. On page 40 of our book, the author discusses an important condition that scholars have discussed in the book of transactions. This condition is called Al-Mualat. What does Al-Mualat mean in Arabic? Shay'un yali al-akhar. Al-Mualat means when something follows the other directly. There is no gap between them. That is the meaning of Al-Mualat. We discussed this condition, if you remember, in the book of prayer, in the book of wudu. One of the conditions of a proper valid wudu is not to have a gap between the parts. Someone washes his face and then somebody rings the door. He goes, he opens the door, he talks to that person, offers him a cup of juice, and then, okay, let me go finish my wudu. No, you broke the continuity of the wudu. One of the conditions that scholars have mentioned in the book of transactions is al-mualat. So the author says that we have two types of transactions. We have a binding transaction and we have a non-binding transaction. Last year we discussed the difference between them. A non-binding transaction is like wakala. I give a wakala to someone to buy something, or wakala in marriage. Is this binding? Meaning, do I have to stick to the wakala, or I can negate it anytime that I want? I can negate it anytime that I want. Let's say today I tell you, I authorize you to go and buy a car for me. You are my wakil in buying a car for me. Now that I have authorized you to buy the car for me, if you buy it, I have to pay it. I have to pay for it. Why? Because I gave you a wakala. I authorized you to buy something on my behalf. Now let's say 1 second before you bought the car, I call you, I tell you, you know what? I changed my mind.
You can.
Can I?
Yes.
Can I negate the wakala?
Yes.
Yes, I can negate the wakala. Why? Because a wakala is a non-binding transaction. Whereas, for instance, buying and selling, you sell something to someone and the sale is done. Assalamu alaikum. The sale is done. Is this a binding transaction or non-binding transaction? Binding. This is a binding transaction. Can I change my mind? No. If I made the transaction, I sit with you, we make a deal. I sell this book to you for $10. You say I accept. The verbal transaction has been done. Can I nullify it? No. I'm not allowed to negate it or nullify it. Why? Because it's a binding transaction. Marriage. Marriage is a transaction. It's an act between two parties. Is it binding or non-binding? Binding. It's binding. After the marriage contract is done, the nikah, the katb kitab, can one of the parties say, you know what, I changed my mind? No, you cannot. It's a binding transaction. Now in Arabic we call the binding transactions aqdun lazim. Lazim means what? Binding. And we call the non-binding transactions, like the transaction of giving a gift, like the transaction of wakala, what do we call them? Aqdun jaiz. Be familiar with these terms, know these terms, because this is very important in Islamic law in the book of transactions. So we have aqdun lazim and we have aqdun jaiz. The aqd lazim is the binding transaction. The aqd that is jaiz is the non-binding transaction. So these are the two types of transactions that we have. Now the author says on page 40, when it comes to a non-binding transaction like the wakala, can there be a gap between the initiation of the contract and the acceptance of the contract? The initiation of the contract means what? Al-ijab. I, as the muwakkil, as the one who's giving the authorization, I initiate the contract. I say, I give you the wakala to buy me a car. That's the initiation part. In order for this transaction to take place, what does the other side have to say? Is he forced to accept it? No. He has to say, I accept to be your wakil. Can there be a gap between my statement as a muwakkil, as the one who's giving the authority, and the time that the other person accepts? Can there be? He says yes. Why? Because it's a non-binding transaction. So if I give you, Ali, I tell you, I give you a wakala to buy me a car. I say it today. And I never withdraw my statement, right? Tomorrow you come and say, I accept. I thought about it tonight, I accept. Can you do that? Yes. So the muwalat is not a condition, a shart in al-aqd al-jaiz. The non-binding transactions, it does not have to be consecutive, immediately after the initiation. There can be a gap between the ijab and the qabul, the initiation and the acceptance. Even if it's a week later, even if it's a month later, that's fine. What about al-aqd al-lazim? Al-aqd al-lazim is a binding transaction, like the sale transaction, buying and selling. When it comes to buying and selling, the author states that some scholars have stated that it is a condition for the validity of the transaction to not have a gap. وَاخْتَلَفُوا فِي الْعُقُودِ اللَّازِمَةِ فَذَهَبَ الْبَعْضِ إِلَىٰ أَنَّ الْمُوَالَاةَ شَرْطٌ. Some scholars say yes. When you say, I sell you this book, and the other person says, I accept, there must not be a gap. However, وَقَالَ آخَرُونَ إِنَّهَا لَيْسَتْ بِشَرْطٍ. A number of other scholars have said, no, it's not a condition. So what if there's a gap between the initiation and the acceptance? What's important is the intent. If I still intend to sell you this product, even if you accept a week later, a month later, as long as the intent is there, that is a valid transaction. Yes, if I change my mind, if I withdraw my initiation, then at that point, what happens? It's no longer a valid transaction. So, this is what a number of scholars have said. Now, Sayyid al-Hakim rahmatullahi alayhi, in the book Nahj al-Faqaha, he says the following. He says, it appears to us as scholars that as long as the intent is there, it suffices. There can be a gap between the verbal initiation and the acceptance. Why? He says because when you look at the urf, when you look at the public out there and their perception of transactions, the public states that if you, the seller, you express your intent to sell something and you still continue that intent, you've not changed your mind, anytime after that the other party accepts, it's a binding transaction. Doesn't have to be the same minute. It could be the next day. It could be the next week.
Sayyidina, I have a question. Is it the verbal acceptance of the buyer or paying the money, for example? Or
well, that goes under the section of whether transactions can be verbal or non-verbal. Okay. So historically, many scholars have maintained that it has to be verbal. But modern scholars, if you remember from last year, modern scholars are saying that al-mu'atat, non-verbal transactions are still valid. Yes. So let's look at the general right now. Let's say you make a deal with someone. How much is this? Okay, this is for $10. The seller of that book says, I sell you this book for $10. You're thinking about it. You don't say anything. You go home that night, you think about it, you're convinced. You come next day and you say, I accept that deal. Whether you say it verbally or in a written way or through sign language, it doesn't matter. Or I just put the $10 indicating my acceptance. Is that valid, or we have to make a new contract? Sayyid al-Hakim says it's valid. Because when you ask the public, the urf, they tell you as long as the seller has the intent to sell it, he's not changed that intent, then this is a valid transaction. So what if there's a gap? Why does this gap hurt? He says it doesn't hurt. And you can just ask the public, and the public will tell you about that. And he gives, an example here. Yes, if by the time the other person, the buyer, the customer, by the time he comes a month later, the seller has changed his mind. He's like, I initiated this contract last month. Now you accept? No, I've changed my mind. Obviously here, it's not going to be a binding transaction. So as long as the intent is there, it's okay if there's a gap. So what? Now why is the author mentioning this? Because there are scholars who've said there cannot be a gap. There are scholars who have said that. Then the author says that according to us, the scholars of Ahl al-Bayt and the Shia school of thought, there is something called the majlis. The majlis means the session. So other scholars from other schools of thought have said, if you're in a session and you're discussing a transaction, and the seller says, I sell you this book, if the customer, the buyer, leaves the session, the majlis, that's it. That initiation is negated. They need another initiation. Whereas our scholars, they say, no, that majlis is not a condition. Even if the customer steps outside the majlis, next week he comes and he says, I am buying this, it's still valid. Now you can argue, but we have so many hadiths about the majlis that once the session is over, there are some changes to the transaction. He says all those hadiths that we have about the majlis are about the khayar. Inshallah, later in the book of transactions, we'll talk about the khayar. What is the khayar? The khayar is basically the option to negate the transaction. You are in a session with someone and you buy his house. He tells you, I sell to you my house for $200,000. You've already done your research, you know which house he's talking about. You say, I accept. The minute you say, I accept in Islamic law, there you go. You have a binding transaction. Now, in Islamic law, as long as you're still in the same session, no one got up and left, can you change your mind? Yes, you can. We call this khiyar al-majlis, the option of the session. Which means as long as I'm still in the room with you, even though I signed the paperwork, I did everything according to Islamic law, as long as I'm here with you in the session, I can change my mind. Let's say I just said, I'll buy this house. And then my brother calls me, he's like, look, we found you a better house. I can negate it. But what happens the minute I step outside? Once the majlis is over, the session is over, that's it. It's a binding contract. I cannot negate it anymore. So the author says these hadiths about the majlis, they're talking about this khayar, the option to negate the contract. They're not talking about the validity of the contract itself. You don't need to be in one session to have the initiation and the acceptance for it to be a valid contract. You can decide on the details. Then the buyer, the seller, the buyer, he says, I sell you this house. And then in the next session you accept. That's okay. That's fine. Yes.
But this is on the buyer's side. But the seller has to stick with the price he put in the setting.
No, he can change his mind too as long as they're in the session.
Oh, he can.
Yes, of course. Both sides can change their minds.
The other side signed with
yes, the other side signed. We're still in one session. Nobody left. The seller is regretful. He gets a better offer. According to Islamic law, as long as he's in the majlis, he can change his mind.
You know, overseas when you buy, like here, you can return stuff.
You can return.
Overseas, when you go to the store, once you walk out with the stuff, whatever it is.
See, because when you walk outside, the session's over.
Yes, that's it.
If you're inside the shop, you can still change your mind.
Yeah.
But once you step outside, the session's over, that's it. So this is the default Islamic law. By the way, sometimes you can put your own conditions. A seller can say, I will only sell to you on the condition that you have no khiyar al-majlis. Once you say yes, you say yes. Even if you're still in the same session. Sometimes you can put your own conditions. But we're talking about the default Islamic law. What is the default? So the author says that this majlis that you hear in the traditions or in the fatwa of scholars, that's about negating the contract. Otherwise, it's not a condition to have the ijab and the qabul, the initiation and the acceptance, the initiation from the seller's side, the acceptance from the buyer's side. It doesn't have to be in one majlis. There can be a gap between them. Now, by the way, this point that there can be a gap does not apply to all uqud. It does not apply to all transactions. In the book of bay', buying and selling, it does apply. But in marriage, it doesn't. Many scholars have said that if the wife initiates the contract, she tells the husband, zawwajtuka nafsi, immediately he has to say what? Qabilt. What if he says next day qabilt? A lot of scholars have said no. Over here, that's not a valid marriage contract. So see, there is a gap here. So al-mualat, which means not to have a gap, is it a condition in the book of marriage?
Yes.
Yes, it is a condition. But is it a condition in the book of bay'?
No.
No, it's not a condition in the book of bay'. So you'll find that different types of transactions have different types of rulings. Yeah. Interestingly, I'll mention this as an anecdote. Some scholars believe that in the book of marriage, if the woman initiates the contract and the man does not respond, as a precaution, she cannot initiate another contract with another man until she hears from him. So what if he stays quiet for a long time? She's stuck. Yes? Ayatollah Khoi, that was his fatwa. He had ihtiyat. He's like, when she initiates the contract, there is some sort of link between her and that man. We're waiting for him to reply. Because if he says qabilt, that's it. He's her husband. So we have to wait for him to say qabilt. What if he disappears? We have no access to him. He says ihtiyat. Ihtiyat, she cannot marry another
Once
man.
he leaves the majlis without saying qabl, that means he didn't.
No, maybe he's thinking about it. Yeah, if he signaled, if he made a clear sign that I don't accept, yeah, sure. But let's say he kept it open-ended. He wants to think about it.
But he can.
According to his fatwa, one of my teachers told me, who's his student, he said, according to his fatwa, ihtiyat, she has to wait until he responds. She can't say, khalas, let me just, negate this contract. You have to wait. Does he accept or not?
Yeah.
What do you mean if it's the other way around? Well, usually in the way the marriage contract is worded is the woman has to initiate it. Now let's say the man initiates it, same thing. Same idea. Now, why did I bring this up? A controversy happened during the time of Ayatollah Khoi. A woman in Najaf, she initiated a marriage contract with Imam al-Mahdi. She said, speaking to the Imam, "Zawwajtuka nafsi." So they asked Ayatollah Khoi, legally, what are the repercussions? Because we know the Imam, because he's in ghaibah, he's not going to respond. He gave a hukum. As a precaution, she has to stay single to the rest of her life. Because that's his fatwa. His fatwa is in the book of marriage. If one side initiates the contract, the other side doesn't respond, you have to wait until he responds.
Sayyidina, shouldn't he be present in,
No, the person can be ghaib. See, right now, if I say, I sold my brother this water bottle, and then he hears about it, he's like, you know what, that's a pretty good deal. He says, I accept. That's fine. Even if he's not present, one side can initiate. Yes. So his fatwa was that if one side initiates the marriage contract, we have to wait for the other side to respond. Do you agree? Do you not agree? If there is no way to find out whether the other side accepts or not, he says as ihtiyat, the other side cannot enter another marriage relationship. So yes, his fatwa was as a precaution, if you follow me. Of course other maraja have a different fatwa. He says if you follow me, as a precaution, don't marry anyone else. Because how is the Imam going to respond to you? Yes, brother.
Yeah, so I was going to ask, in this situation, would silence be a sign of acceptance?
It depends on the setting and the society. If in that particular setting, silence means no, or it means yes, we can go by it, sure. But let's say the other side did not indicate anything. Then the debate comes.
Sayyidina, shouldn't he say qabiltu verbally, the group?
In the marriage contract, yeah.
He should verbally say it.
He should verbally say it.
Silence means yes, he should say it.
Yeah, he has to say it. But let's say he's waiting, he's thinking about it.
Yeah.
Some maraja, their opinion is she cannot initiate another contract until she hears from him.
Yeah.
He tells her, I qabiltu or ma qabiltu. Yes. By the way, even the verbal, inshallah, in the book of marriage, we talk about this in family law. Does it have to be verbal? Does he have to say qabiltu in Arabic? There are some scholars who are flexible. They say, yes, obviously it's good to say qabiltu in Arabic, but if he indicates in any way that he accepts, it's fine. But because marriage is an important sacred relationship, scholars always want to do ihtiyat. Otherwise, there are some scholars, some maraja, who believe you can even say it in English. Any language that indicates they're marrying each other, even if she says it in English, that's fine. But the mainstream maraja, they have ihtiyat here. They say as a obligatory precaution, say it in Arabic.
But Sayyidina, إذا ما بيعرف Arabic, if he doesn't understand Arabic, it's better to be said in English, maybe in Arabic and English.
Yes. They could be both, or they give wakala to someone who knows Arabic. Yes, that would be the precaution. But like I said, there are many scholars who say any languages is fine, yes.
Said, I remember about 10 years ago, we were in Chicago, and there's a sheikh of my brother. And my brother has he doesn't know how to speak Arabic. So قبلت like 15 times.
So he can memorize the word, yeah.
He couldn't say it right. Yeah. And then I remember my uncle said it for him.
Yeah, he said it for him.
Right?
Yeah, he gave him wakala to say it on his behalf. Yes, that's fine.
cause something the
Yes.
right way he couldn't say it.
Yes. So a lot of times they'll do the wakala in the marriage contract to make sure that it's said properly. So, in any case, in the book of buying and selling, mu'alat is not a shart. It's not a condition, meaning there can be a gap between the initiation and the qabiltu. There can be a gap. It's fine. The next discussion on page 41 is at-ta'liq. Contingency in bay'. We have two types of contracts. We have the fixed contract and we have the contingent contract. The fixed contract in Arabic is called munajjaz. Be familiar with this term. Munajjaz. Munajjaz means it's fixed, it's done. It's not contingent on anything. You initiate the contract right now, not based on any other conditions. For instance, I tell the customer, I sell to you this water bottle. He says, I accept, done. What type of bay' is this? Munajjaz. It's not contingent on anything. The other type of transaction is called the mu'allaq. The mu'allaq. What does mu'allaq mean in Arabic? What does it mean? Stuck? Suspended, right? Something that's suspended. Mu'allaq basically means contingent, dependent on something. Okay. Take this example. If I tell the customer, I sell to you this book if Zayd approves, if my father approves, if my spouse approves, or if X traveler comes back tomorrow, or if X thing happens. See, it's contingent. It's not a fixed transaction that's done right now. No, it's being dependent on a condition. Is this a valid transaction? In the past, people did not know when the traveler would come back. Is he even alive? Is he dead? Where is he in the way? So I'll tell you, look, I'll sell you this house. I don't need this house anymore. But on what condition? If that traveler comes back. So if he comes back, then we have a sale. If that traveler does not come back tomorrow, what happens? There is no sale. Or I make it contingent on someone's approval. I tell you that I sell this book to you if my teacher approves, if my friend looks into it and he approves, because he's a specialist, let's say, in the world of stocks, right? Is this a valid transaction or no? This is called Al-Muallaq in Islamic law. The author states that the mashhur, the majority of scholars throughout history, have stated the following: At-ta'liq batil. Whenever this transaction becomes contingent, it's invalid. The majority of scholars have said that. Why? Because they say the two parties who are doing the transaction, they must be certain and they have yaqeen that the transaction is going to go through. But if there are any uncertainties, how do I know if this traveler is going to come or not? How do I know if this person is going to approve or not? If there is no certainty, then that's not really a valid transaction. You have to have certainty at the time of making a transaction in order for it to be valid in Islamic law. Okay, so that's the majority of scholars historically. The author says, but there is a group of scholars who say no, at-ta'liq is fine. If the transaction is contingent, that's completely fine, it's completely okay, and it's very valid. And we have three types of ta'liq, three types of contingencies. The first one, you stipulate a condition, but you already know the result of the condition. The example that the author gives on page 42 is this example. Bi'tuka hadha, I sell this book to you, in kana milki, if it's mine. Let's say you go somewhere and there's mixed up books, you don't know whose book belongs to who. So you take this book and you say, I sell you this book if it's mine. Now you know it's yours because you opened the first page, your name was on it. So you already know the outcome of this condition, right? You know it's mine. So this is the first type. The second type is something that the condition has not been fulfilled yet, but you already know it will be fulfilled. Like what? An example of that is the beginning of the month. Today is September 14th. In a couple of weeks, it'll be the 1st of October. So you tell the customer, I sell this book to you if the 1st of October comes. Will the 1st of October come?
Yes.
You have certainty, right? Unless the day of judgment happens before that. But you have yaqeen, you have confidence that the 1st of October is going to come. So this is the second type of condition. It has not been fulfilled yet, unlike the first one. You already know it's your milk right now. You already know you own it. In the second example, the condition has not been fulfilled yet. It will come in the future, but you know it will come. The third type is the one that's debated by scholars. It's in the future, but you don't know if it will be fulfilled or not. I sell this water bottle to you if X traveler comes. If I make a profit at the end of the month. It could happen, it could not happen. So we said the mashhur of the scholars, what's their opinion? Is this valid?
No.
No, it's not valid. But some scholars, especially some modern ulama, what do they say, like the author? The author of this book, Sheikh Muhammad Jawad Mughniya rahmatullahi alayhi, he says yes, it's a valid transaction. And he says Sayyid al-Yazdi. Sayyid al-Yazdi was one of the great maraja of Najaf. He's the author of the book Al-Urwatul Wuthqa. Al-Urwatul Wuthqa is a fiqh book that today, the maraja, when they want to teach fiqh, bahth al-kharij, the highest level of fiqh in the hawza, they basically go by his text. That's how important it is. Was Shaykh al-Na'ini. Shaykh al-Na'ini is the teacher of Ayatollah Khoi. Was Sayyid al-Hakim. He says these great scholars, all of them say that if you have a ta'liq in the transaction, you have a contingent condition like that, it's valid. It's fine. Okay. What's their proof? As Sayyid al-Yazdi says, one proof against this ta'liq is that there is ijma'. There's almost consensus in history that this type of transaction is not valid. If you put a condition that might happen in the future or it might not happen. He says this ijma' is not binding on me. Why? He says because which consensus is binding? The one that gives me yaqeen, this is the position of Sharia and this is the position of the Imams. When sometimes you see all scholars unanimously throughout history have an opinion, you're like, okay, they obviously got it from the Imam. As Sayyid al-Yazdi says, no, when I look at this issue and the way the scholars have argued their point, it does not give me yaqeen and certainty that they're reflecting the opinion of the Imam or Sharia. It's just their ijtihad. Why? I can tell from their arguments. For instance, they say, well, how can this be a valid transaction if you don't know the traveler is going to come or not? She says, so what? That's fine. As long as the urf, the public, sees this as a valid type of transaction, then it's fine. It's a kind of, it's like an options trading. Today we have options trading in the stock market. People do that all the time, that's fine. So it's like this ijma', this consensus is not binding on me. As for Shaykh al-Na'ini, he gives an interesting piece of evidence over here. He says, when you look at most Islamic rulings, you find that they are mu'allaq. In fact, there's contingency in them. For instance, when the Quran says pray, aqimus salah, who's it talking to? Only the Sahaba who were present when the Prophet said? Or to every Muslim? But how can you prove that? The Quran didn't directly talk to you. You did not exist at the time of the revelation of Quran when the Prophet said it. So how is it applying to you then? It's mu'allaq. What does it mean it's mu'allaq? That means the law is you have to pray if you exist as a person who's mature, who understands. And the conditions apply to you, then you have to pray. See, there's a contingency embedded in all laws. When the Quran says, Aqimus Salah, you have to pray, the ruling is prayer. You have to pray. But who's the subject? If there is a mukallaf out there who hears this verse, he has to pray. See, if. That's how we can apply it to all eras. Otherwise, if you don't take the step, the Quran doesn't apply to you directly. The Quran never spoke to you. The Prophet never spoke to us. We did not even exist for us to be the audience of the Prophet. So how are we the audience of the Prophet? Through this contingent issue over here. That the Prophet basically was saying, if there is a person out there in society and the conditions of these laws apply to them, they have to implement them. See, there is some level of contingency there. So basically, as Shaykh al-Na'ini says, that's one proof that our laws are based on contingencies. So what? Let's have this contingency in the, in the transactions as well. Another proof is a more powerful one. He says we have Islamic rituals that are based on ta'liq. There's ta'liq and contingency in them. Like what? Like what? Like nadhr. In the book of nadhr, how do you make a vow, a nadhr? Tell me if this is valid. Oh Allah, if you bless us with a child, then I make a vow to do so and so. To pray Salat al-Layl for 40 nights. Is this a valid nadhr? Yeah, but is this a valid sigha for the nadhr? Yeah. Of course, but there's contingency. Do you know if you're going to get a child or no? No. Ya Allah, if my father is healed, then I make a vow to, let's say, give charity to the poor, or to go to Hajj, or to go to ziyarah. This condition that you're putting for the nadhr, if my father is healed, do you have knowledge that it's going to happen or no? No. It could happen or it could not happen. But is the nadhr valid? Yes, it is. So he says in our Islamic law, we do have examples of ta'liq in transactions. Remember, nadhr is a transaction. In the end, it's a type of transaction that you do with Allah subhanahu wa ta'ala. So An-Na'ini is saying, just like we have these examples, don't come and attack me and say, oh, how are you making bay' like that too? It's like, so what? What's the big deal? I know most scholars in history have not allowed that, but I'll allow it because I have sufficient proof. So a number of recent scholars have said having ta'liq, contingency in the bay' is valid. We don't see any issue with it. So what do you say about this?
It's a condition, so it makes sense. Why not? If the condition is fulfilled, the bay' is fulfilled. That's good. For example, I'm selling you this house. If the person renting it leaves, once he leaves, I'll sell you the house. That's it.
And you don't think that at the time of making the transaction, you need to know the outcome? You don't have to know. Do you need to know the outcome, or it's fine if you don't?
No, it's fine. If he leaves, I'll sell you the house.
Okay.
If he doesn't leave, you can buy.
So some scholars, maybe they were under the impression that how do you rationally make a transaction? Because see, in Arabic, we call the transaction aqd. Aqd is to tie a knot. You're binding something. How do you make a transaction and you intend it without knowing whether the condition is fulfilled or not? So like, how do you really intend it? It's like flying in the air. It's not something set. Maybe that was the problem they had with it. But modern scholars are saying when we analyze it, we don't see any issue with it. As long as both sides understand this concept and they've both agreed, fine. Like you said, he can say, the owner of the house can say, I sell you my house if the tenant who's renting the house now leaves on the 1st of October. I don't know if he's going to leave or not. If he leaves, we have a sale. If he doesn't, there's no sale. That's fine. So I wait until the 1st of October. If the condition is met, the tenant left, it's my house. Automatically, I don't need to do anything else. We've already made the transaction. If October 1 comes and the tenant is stuck in there, he's not leaving anywhere, taking advantage of COVID-19, right? Then there's no sale.
I have a question, Sayyid.
Yes.
Isn't sensitive. Some people like they write their house for their kids if they die. The house goes to their kid. It's not inheritance.
Okay, so
The condition.
yes, some say I have a condition to give this house to, let's say, my son or my daughter if I die.
Yes.
This is not valid.
No.
Why? Because first of all, this is not a sale. You're not buying or selling anything. You're giving a gift. While you're alive, you can gift anyone whatever you want. But the minute you pass away, this house is no longer yours for you to give it to your son or daughter. It becomes the warathas,
What is it?
the inheritors.
What one is 1/3 of your?
Okay, up to 1/3, Islam has allowed you to designate what happens to your inheritance.
Yeah.
So if that house is from the 1/3, you can give it.
can.
Otherwise, you cannot. That's why that statement is not valid. Because if you analyze it, what is the statement? When you say, when I die, my house goes to my daughter. What exactly are you, is that a gift that you're giving? So we tell the person, we have two scenarios. Either you're alive or you're dead. If you're alive, okay, give the gift now. The minute you pass away, it's no longer yours for you to gift it.
Okay, can you say it in a different way? This house is for my daughter, but I have حق الانتفاع منه إنه live in it.
Yes.
I die.
You can make hiba mashruta.
Okay.
You can give a gift with conditions. What's the condition? You say, right now, while I'm alive, I'm breathing, I'm alive, my house is for my daughter, but I'm only giving it to you as a gift on the condition that you allow me to use the house whenever I want. If she accepts, then yes, it's a binding transaction, it's a hiba, and that's a good workaround, yes. So we need an Islamic workaround. I know some people don't do this, and then the house ends up going to that daughter. This is a violation, this is haram. This house is ghasb, because the other inheritors, her siblings for instance, they have a share in it. Yeah, but dad says I can take it. No, he didn't have the right. If he gifted it to you in his lifetime, sure. Hani'an, it's yours. Up to 1/3 from his inheritance, sure, he can give it to you. But if the house's value is more than the 1/3, no, you cannot take it. So the question is, okay, then how can a father gift that to his daughter? He has to gift it to her in his lifetime, and then he can put a condition that, you know, give me the right to come to the house whenever I want, to use it whenever I want. Yes, so he can put conditions like that.
Said, what if the dad writes wasiyah?
Yes.
Like, this
The wasiyah, he only has control over 1/3. Yes. 2/3 has to go to the inheritors. By default, anything I own will have to go to my inheritors, the waratha, my immediate family.
Okay.
It will go to them by default.
Okay.
Everything that I have is split according to a particular percentage in Islamic law. Now 1/3 of what I own, I can designate that I want it to go to a masjid, to a hospital, to an orphanage, to my son, my daughter. I have the right. But only up to 1/3, not more than that. If it's more than 1/3, it's haram. Unless, of course, the waratha, they agree, they accept. They have to willingly consent to it. When a person dies, they don't own their money anymore. So they can't dictate what happens to it, except 1/3 of it you can dictate. So if you want, let's say, your house to go to one of your children, by the way, this always happens in the community. How? You see, the father goes and he makes a legal document in the court that only my daughter fulana or my son fulan gets my inheritance. By the way, that's haram if you deny others their share. So you ask him, why? It's like, say it. All my children abandon me, they don't even care about me, they don't even call me, except her. She's the one who checks on me, she takes me to the doctor, or my son, he's the only one who cares. So I don't want those others to inherit a dime from me. We tell that person, we understand your frustration, Allah's going to punish them for abandoning you, but you don't have the right to deny them inheritance. It's not yours. This is God, this is divine law. So it's like saying, I really don't want them to get a dime. What do? So we tell them, if you really want that, give your daughter now everything you have as a gift. Tell her, all my money in my bank account, all my properties, everything, I give it to you as a gift right now. She has to accept, That's it. It's all hers right now. That way, if he passes away, he didn't own anything to leave as inheritance. So that would be a workaround, yes. But if the person does not do this workaround, it's haram for them to make such a will. And many Muslims, unfortunately, they make this violation. It's a big violation in the eyes of Allah. It's usurping the rights of others. It's like stealing. There's no difference between this and going and stealing from someone. It's their haqq. Now someone will say, yeah, but I don't want to give everything as a gift to my daughter. What if she flips against me? How do I know? Well, that's a risk that you have to take. Unless you put a condition like that. That I give you this gift on the condition that you always allow me to use this house. You won't kick me out of the house. You can put a condition, sure.
سيدنا, if it's verbally said وما عملوا عقد ما سجلوها مثلا لنفترض verbally said I give you this house
and she accepted.
She accepted.
It's according to Islamic law this is binding.
Okay.
According to Islamic law this is binding, yes. So that's why it's important when things like that happen to have witnesses who document it. Because if you don't have witnesses, there's going to be dispute. And then you have to prove your point. So it becomes problematic from that aspect. That's why it's always recommended in Islamic law, have witnesses, write it, have a signature, so that others will believe you. But Islamically, between you and Allah, the verbal statement is enough. So just have witnesses. A recording, have 2 witnesses from your family who says, we heard that verbal transaction, or have the person write it. But Saddam Allah, yes. Between you and Allah, it's a done deal. It's yours. You have the right to it, yes. By the way, I read an article maybe last year that this father, he was getting older and older. He had this amount of money in the bank account and he didn't really know whom to trust to give this money to and to spend it on him when he needs. Because he figured maybe as I age, I cannot make good decisions for myself. So what did he do? He went and he talked to his son. He told him, my son, I'm going to give you all my money right now. You're in charge of it. So no one comes and fools me later. Sometimes the lawyers, if they have a good relationship with that client and he or she's aging, they convince them to appoint the lawyer to have the power of attorney. So basically what happens is, some of them are millionaires, by the way. They're getting older, they can't make good decisions. He goes and he signs a paper to the lawyer that all my money, you decide what happens to it. Yes, this happens a lot in this country. So this elderly person, he tried to avoid the situation. What did he do? He went to his son. He's like, my son, you're the closest person to me. I'll give you all my money right now. Let's say it's $100,000. I'll give it to you right now, you own it. But basically, spend on me whenever I need the money. It's like, sure, of course. A few months passed by, the dad needed money. So he called his son, Yalla, give me 5,000. He's like, no, it's mine. And he backstabbed his father. This was, I think, in the New York Times. It was a big controversy. So basically, he had to go and get a lawyer to sue his son and to show proof that the only reason why I gave him is to spend. It was a big mess. But legally, the law was with the son. My father gave this to me as a gift. See, sometimes when you give someone a gift, they could end up backstabbing you. You never know what happens. La ilaha illallah. It's very sad.
Inherit something and they're still alive. Is it better for them to give it to you now before they...
If they really want something for you, they should give it to you now. But put a condition like that. If it's a house, for instance, that as long as I'm alive, you allow me to stay in it and you cannot kick me out. If you put a condition like that, then yes, that would be safer.
Yeah, because a lot of people, especially back home,
yes,
and when they die, they have that, and that's when they pass out everything.
Correct.
So I don't think that's right. I think the parents should give it to while they're alive.
That makes sense, yes. Or up to 1/3 they can write in their wasiyah, in their will. Up to 1/3 they can designate what happens to it. One final discussion here on page 44 and 45, very briefly, is historically many scholars have maintained that the transaction, in order for it to be, Assalamu alaikum, in order for it to be valid, it has to be verbal. بعت, اشتريت, قبلت. It has to be verbal. Can we initiate a transaction in written form? I draft a contract to sell this laptop to you, and you sign it, and we have a transaction. Is this okay or no? Historically, most scholars in the past, what did they say? Historically, most scholars of the past, what was their opinion? Does it have to be verbal or no? Yes. Scholars of the past, they were very strict with these transactions to regulate everything, to make sure there's, no room for someone to manipulate the documents. They said it has to be verbal. That's it. You verbally state, unless you have a medical issue that prevents you from verbally communicating. Like, for instance, let's say you're deaf, akhras, you cannot speak. Okay, fine. Then you could communicate that through sign language or through written form. Today, what are the maraja saying? Can you have a valid transaction non-verbally through written form? بالكتابة أو الإشارة, through signs or through a written document? Yes. Today, most maraja, they maintain that this is fine. You can actually initiate a contract, not necessarily verbally. It could be in a document. You can go online, you buy something, you accept, you put your credit card, and that's it. In the past, scholars did not recognize this as a valid transaction. It's like, where's the verbal agreement here? Yes, the way to do it today, Islamically correct, according to their opinion, is every transaction, when you go online and you buy something, let's say from Amazon, you record your voice. And basically you say, I am buying this product for this price. And then somebody there says, I accept. Then that would be valid. If we want to go by those strict conditions of the past ulama. But today scholars are flexible with these laws. So they say it's okay. It does not have to be verbal. Now what's the proof? Remember, we want evidence. The proof of modern scholars is that the Quran says, أَوْفُوا بِالْعُقُودِ. We discussed this verse last year. أَوْفُوا بِالْعُقُودِ means honor your contracts, basically. Honor your transactions. Fulfill your transactions. When the urf, the public, looks at the word aqd, contract, transaction, what do people understand from this term, this Quranic term? Is it restricted to verbal contracts? Obviously a verbal contract is a clear example of a contract. Or it can be in written form. Do people call a written contract a contract? Yeah. Do they call it a transaction? Can you say in your society, I made a transaction with Amazon.com? Can you say that? Is that true or false? True. So the author is saying, as long as the urf, the public, sees this as a transaction, then the word act applies to it. The minute the label act applies to it, what does the Quran say? أَوْفُوا بِالْعُقُودِ, honor your contracts. So it's a valid contract and it's binding. That's his proof, the author's proof, and maraja today. But in the past, scholars disputed that. They're like, no, aqd means you verbally initiate, not written and sign language and these others. No, that's not good enough. That was their understanding. But today, upon re-examining these laws, it's very clear to us in our society that this is a contract. Question, and this is where you see the role of ijtihad. Let's say somebody lives in China, somebody lives in America. Let's just take this example. Let's say in China, only if you verbally make a deal, it's considered a contract. If you write something on paper and you sign it, in Chinese society, that's disregarded. People do not call it a contract. They don't even perceive it as a contract. I'm just theoretically saying that. So that's the first person. The second person, he lives here in America. And you live in a society that does see written contracts as valid contracts. People call it, yeah, this is a aqd, this is a transaction. He's like, but I never said anything. It's like, so what? But you wrote it. You signed on it. You went on the internet and you clicked. You accepted the terms and conditions. Okay. So we have these two societies. Now let's say you have a Muslim following the marji' in China. And In that society, the written form is not considered a contract. What will the marja' tell him? If he tells the marja', I went and I did this written form, what will the marja' tell him? Is that a valid transaction or no? He'll tell him no. You don't have to honor that transaction. It's not even a valid transaction. But why? What's your proof? Because in your society, it's not even a contract. So whatever you did with the other person, it's not a contract. Maybe it's a promise to make a contract, expressing your intent later to make a contract, but it's not a contract in that society. Now the guy who lives here, he asked the marja', what will the marja' tell him? It is a contract. Now is this a discrepancy in the fatwa? No. Why? See, the Quran says, live in a society where you honor your contracts. In society number one, this is not even seen as a contract. So there's nothing for you to honor. There is no contract. In another society, this is a contract. So you have to honor it. This point, my dear brothers and sisters, is extremely important. And today, one of the biggest discussions in Hawza is to figure out the context for these subjects. That's key. In the book of marriage, inshallah, you'll see that many of today's laws can become binding based on this concept. For instance, if you get married in the West, is there the clear expectation from both sides that if they divorce, they split half and half?
Yes.
Is there that clear expectation? Thus the Maraja will say if it's that clear, such that it's like a given condition when they get married, then yes. Even if it was not stipulated in the aqd, in the katb kitab, upon divorce they have to split half and half. Why? Because there's a clear expectation that makes this a condition in the contract. But let's say you live in Iraq. There is no such expectation. If you want to have this happen, you have to state it explicitly in the marriage contract. The marja' will tell you, in that society, this is the fatwa. In this society, this is the fatwa. Or with house chores. These days, the minute there's a fight between the husband and the wife, well, I don't have to do this, I don't have to cook. The Sayyid said, it's not my obligation to. Scholars say, when you get married today, in today's society, when you get married, is there a clear expectation that I, as the husband, I'm going to be responsible for these things, and you, as the wife, you have to be responsible for the... Is there a clear expectation such that it's like an explicit condition or no? Such that, let's say, just as an example, if the wife, let's say, doesn't cook, not one day, but like just says, I'm not going to cook anymore, does the society see her as violating the marriage contract or no? It's her right, she doesn't have to. It depends on your society. Some societies might see it as a clear expectation, so there is room for a marja' to say, no, it's binding, you have to honor that. But in societies in which it's not a clear expectation, then it's not an issue.
So what about the woman working outside the house, like having a job, and she got married, and the expectation is that she's gonna stay working, let's say. And she
see, we're not talking about any expectation. I know there's always some no, it's a clear expectation. Fi quwwat al-shart. It's like whether you state it in the katb kitab or not doesn't make a difference. It's there. It's that clear.
Yeah.
Is it to that point?
Yes.
If it is to that point, then yes. But many people will probably argue, no, it's not to that extent.
What if your society's expectations are moral law?
Remember, that condition or expectation cannot violate Islamic principles. It must be in line. See, for instance, splitting the wealth upon divorce, right? Islam has left that up to the husband and wife. By default, the wife only gets the what? The dowry. But can they agree on more than the dowry in the initial contract? Of course they can. So if there's a clear condition in that society that whoever gets married automatically half and half, there's that clear expectation, clear condition, crystal clear, such that whether you say it in the contract or no, it doesn't matter. In fact, if you don't want this to happen, you have to actually say in the contract that I don't want this to happen. Yeah. If it's that clear, then it's binding. And it's not violating any Islamic principle. So in any case, the author says there's no difference between the verbal transaction or if you communicate it non-verbally, in written form or in some other form. وصلى الله على سيدنا محمد وآله الطيبين الطاهرين. اللهم صل على محمد وآله